delinquent taxes through my office. We deliver those. When they're paid in full, we deliver them to the county clerk and get that taken care of. They still have to pay all their penalties and things like that.
Mm-hmm.
So, by deferring it there, it's still gonna cost them more, but then their property's not sold to a third party.
And I think that's what the city is finding about on some of these blighted properties. There's so many liens on some of these properties from these companies.
Yeah.
You can't just go in and take some other person's property and raise it, no matter what it looks like.
Yeah.
And those companies are not releasing the liens to allow the property to be
We've had that with the county, with some of our ordinances. We have an ordinance that allows us to go in after certain steps to clean up a property and put a lien on the property for the county money that's spent. Problem is, there's tax delinquencies, there's mortgages that, you're behind all those.
Mm-hmm.
And sometimes you've got a piece of property that's only worth now $5,000 and there's a $20,000 lien on it for a mortgage.
Yeah.
Well, I have to tell the fiscal court, yes, you can go do this. You can go out and spend a few $1,000s to clean this up. But you were at the bottom of the list, and then we have to sue them. Everybody else gets paid first, then we're gonna get paid. I mean, just the way lien priorities fall by law.
Yeah.
Tax liens come first,
Yeah.
before mortgage and anything, but then you got mortgages, and then we have to fall in depending on when your timing of their liens filed. So sometimes it's an economic decision the county has to make is, do you want to spend money to clean this up that you're never gonna get back?
Wow.
So that's when we try to go after the property owner if we can find them. Sometimes they've gone and who knows where they're at, or a mortgage company somewhere holds it and we try to put pressure on them, but I can't really prosecute them.
Well, heck, and they may be in Oregon.
Yeah. So
And-
it's just one of those, there's not a good answer to it. If we could somehow, if the legislature would somehow put us on that same level as a tax lien,
Mhm.
it's where we could go in and do those things, then the county can spend money maybe to clean up some of these blighted areas, but you just, at some point, you have to make a financial decision, and that's up to the fiscal court. That's not my call. My job is to advise them of the law, to keep them legal on whatever they do. My job is not to tell them what to do. That's why they're elected as magistrates and judge executive, to make those policy decisions. I'm there as their attorney, not as the person that says, this is what you need to, what you should do. Sometimes I will lay it out to them like I just did with you, and say, here's where you're gonna stand. If you spend it, now you decide. If you wanna do it, you can legally do that. You have to decide as a policy, is that the best use of taxpayer dollars?
Gotcha.
To do.
And I wanted to segue into fiscal court because we hadn't talked to him about your role with them. And as you said, you provide legal information for them. Beyond that legal, when they're trying to make decisions and you're telling them the fallout and where they stand legally, what other kind of things would this position do with fiscal court?
That's a lot of it, is making sure that they can, if they have a question, can we do this or not?
Mm-hmm.
When they get around to drafting an ordinance, a lot of times, if there's an ordinance on a particular issue, I will assist them, or sometimes they'll draft one and send it to me, and then I'll look at it and say, well, we need to make this change or that change.
You got to put it in legalese.
Yeah. I mean,
all the with-throughs and herefores,
right,
and all that kind of
by
stuff.
law, an ordinance has to have certain provisions, and there are steps you have to do to pass an ordinance, and there are some ordinances I draft from scratch. There are some they say we need an ordinance that does this, this, and this, and then I draft the entire ordinance. Like I say, there are some, like say they will go and get one from another county and plug in Pendleton County and send it to me, and then I'll look it over and I'll say, well, what about this or what about that too, but if it's in form, I'll say it's perfectly legal, or tell them here, well, we need to do this or that. But so I look over those things. I look over contracts that the county signs. Any contract they sign for whatever, mowing the side of the road to, having contracts with the state for state funding for projects to bond issues. There's just a whole host of those things that I review all those. I have the duty to review the bills that the fiscal court pays every time, to review that document to make sure that they're spending money lawfully, that they're not buying things that they cannot buy, and spending taxpayer money on things that they cannot spend taxpayer money on. So That's part of my duties. By law, I'm supposed to be at every fiscal court meeting. And, you know, there are occasions.
Caucus and meeting?
No, I'm not required to be at caucus.
Okay.
Because caucus is not an official meeting. And basically, the fiscal court has told me, you know, when Judge Bertram was there, Henry said, you don't have to come to caucus meetings. And I said, thank you. I said, but I've always said, if you need me, if there's an issue, you want me there, I will be there. But, you know, that's when that's when they hash out a lot of things. They can't vote on anything, but they can, those meetings are open to the public. They can discuss, they can argue, whatever, or they can have people come and talk to them about proposals and you know, as they do their investigation on what they want to do in passing some ordinance or agreeing to do this or that, whatever it may be. They don't require me to come, so.
And it can be 5 to 6 hours in length.
Yes.
I mean, easily.
Yes.
I made comment on some other ones. A lot of times their caucuses are Mondays. Of course, that's our press day.
Right.
And I've gotten there to caucus at 5 p.m. and at 8 p.m. I tap out and go home.
Right.
Because they're still going strong and I'm exhausted.
Right, and it's, I mean, as I say, I have told them they ever need me, I'll be there. I mean, that's my job, to be where they tell me to be. Legally, I'm required to be at the regular meetings of the fiscal court, you know, and I'm there unless there's occasion. I'm rarely sick, but years ago I walked in on one and they saw I was green and I said, I don't feel good. I said, go home. but, you know, I always, before that meeting, I have the agenda. You know, Henry started it and David has followed up with the Dropbox system where everything is going to be on there I can look at. And usually on Mondays and Tuesdays, I start looking as things get put on there. I look at the agenda. I look at anything that the bills. I look at, you know, what's coming up. So when I walk in, I know what may come up in that meeting that I have to be prepared for. And you know, that's a tremendous help to be able to, and to be able to look over those bills so that I've looked them over well before I get there. The county treasurer has to file an annual statement every year of how money's expended. I have to review that, make sure that is done properly before she sends that off to Frankfurt and before, you know, she publishes it in the paper. So, you know, there's a lot of those little things that the county attorney is required to do, you know, just to make sure that, you
It's
know, to
exciting stuff.
Oh, it's so exciting, but it's there to protect the taxpayers. You know, if they do something, you heard me the other night, they were talking about doing something at the meeting Tuesday night, and I said, fellas, I don't see it in the law that you can do it. Somebody in Frankfurt said, well, there's other counties doing this, but he even said he didn't think it follows the law, as you'll recall that conversation. And I have a duty, if they're violating the law, to sue the fiscal court.
Well, and that was the question I was going to ask
Yeah.
you. I know with the school board and the school district, the school board hires their attorney, and it is technically the school board lawyer.
Right.
So if there became a lawsuit between the school district and the school board, that lawyer represents the school board, and the school district would have to seek a different. Do you represent fiscal court or the county?
Well, depending on what's going on, but yeah, I am an independent office.
Okay.
They cannot tell me what to do, if you will.
Okay.
You know, they can obviously tell me that here are things that, like I say, look at an ordinance. That's part of my job description. You know, I mean, but they cannot say you need to prosecute this, or you need to do, you know, that. You know, you need to, I don't know, you know, go out and investigate something. You know, I'm an independent office, so yes, I work for them, so that, you know, to be their legal advisor. But as I said, my primary responsibility is to the taxpayer, so that if they're doing something illegal, my duty is to protect the taxpayer and to stop. You know, I've never had that come up. And, you know, I've had to occasionally tell them, I wish you could do this. I know it would be good to do this. You know, I got a question the other day about putting some gravel down. You know, the county can do bus turnarounds for the school system and maintain them and put gravel down. Well, there's a private drive that goes to a bus turnaround. Can we put gravel on that? No. I understand why, but you'll be breaking the law. I said, look, and out of abundance of caution, I'll call our guru down in Frankfurt that handles your insurance and say, send it down to him and see if he agrees with me, and he did. You know, I said, but I'll make sure I'm right. But, you know, it's like, no, you can't do this, guys. And if you do, you're committing a crime. You know, so no, you can't do it. I understand why you want to do it and would love to do it because it's going to help a situation that says it's going to cost the county less than $300, but by law you can't do it. And you know, I've had that, like, you know, you were aware the other night when they were wanting to do something with the code and, you know, state statute, and you know, I think nobody was wanting to do anything illegal.
That's
Make
what
that
I'm
clear.
saying, yes.
That they were exploring. There's been some things like purchasing property at auctions, you know, surplus auctions and things. We're limited to $20,000 or else we have to take bids. And is there a way, you know, they just asked me, is there a way we can, in our administrative code, bump that up for those, just for that purpose, to go buy a piece of state equipment or something that the state's selling at auction that's gonna bring more than 20,000, so we don't have to advertise.
But still, they could spend $22,000 to buy that piece of equipment, but that might save $20,000 if they had to buy it somewhere else.
They had to put up for bid.
Yes.
Yes, I mean,
So if it's up for bid, they may have to spend $40,000 for the same piece of equipment that they could have got at the state surplus for 22.
right.
Okay.
So yeah, anything wrong. It makes sense, you know,
Yeah.
common sense, but you know, unfortunately, sometimes common sense and law don't match up. But,
Back to those law professors who are writing those.
yeah, and you know, $20,000 still a lot of money.
Yeah.
But $20,000 20 years ago or 40 years ago when this was written
Yeah,
is not the same as $20,000 now.
that's true.
So, you know, sometimes the legislature has to make that change. So, you know, but I had to say, no, you can't spend more than $20,000. Our code says that, but not only does our code say that, state law says if it's over $20,000 for a county, you have to advertise for bids, competitive bids. And, you know, like I say, wasn't anybody wanting to do anything wrong. It's just, you know, this would just make sense to be able to go and spend $22,000 on a piece of equipment that you can buy nowhere else for that amount of money. It will be a savings to the taxpayer.
Absolutely.
But the law says no.
We had a situation when I was first athletic director, and it was almost like I don't want to say it's a kickback, but it was one that I understand the reasoning, but in this scenario, it just didn't make any sense. Same way, if you spend more than $20,000 in a business, you got to bid it out. If you look at all the school district, we spent more than $20,000 with Teresa Peoples. And so the state said she must be on the bid list, which means she has to then give a percentage of all of her sales that goes through the school to the state as a cost for being on the bid list, that they get so much of it. Then her name goes on the bid list. She got 0% of new business from being on the bid list. So
Right.
she was having to give the state money because we were spending more than $20,000 by wanting to keep it local.
Right.
So in reality, she was getting less money
Right.
because she was required to get on the bid list, because we may spend $25,000 with her when you look at all the 4 schools, the athletic
Yeah.
department, the boosters, all of that stuff.
Yeah.
And it was like, it's just,
Yeah, I mean, sometimes common sense, we know what's right, what should be done, but the law doesn't always match up with common
Yeah.
sense. I mean,
And-
and there are reasons for that. I mean, there are reasons that those protections are in there, because, you know, like I say, years ago, $20,000 was worth a whole lot more than it is now. You know, having that kind of freedom to just go spend without bids, you know, the thought was you would overspend on things. You would buy from your buddy
Yeah.
or something, you know, and you know, and when you can pay them a lot more, you know, like the military and that $20,000 hammer you always hear about, that you do that kind of foolishness.
and in fairness, we really haven't heard those stories as much in the last 20 years. Then,
No.
my goodness, it was in the 80s, it seemed like every week there was coming out with an $80,000 toilet somewhere, somehow,
Yeah.
those kind of things.
Yeah.
Couple more things I want to touch upon. And I think we did a good job of going through all the things. And obviously, in going the breadth of things, you have to be well versed in wide variety of the law, from
Right.
drug to prosecutorial to fiscal court to disability. How do you become so wide breadth as far as knowing so much?
A lot of it is experience. I mean, you know, obviously you learn as you go. You know, I think experience is the best teacher. I have a variety of resources. I mean, I read the law, obviously try to keep abreast of changes in the law. Our county attorney association and so forth sends us things out when there are bills that are coming through the legislature that are of interest to us that will put us on alert of potential changes that might come, and then obviously the ones that do change that affect us as county attorneys. And then there are some other resources that you can tap into, but I think experience is a lot of it. I find less and less that I have to spend less and less time researching the law on a question, than I maybe did years ago. Of course, when I started as a prosecutor, before that I did defense work. Mm-hmm. So, I was very familiar with criminal law as a defense attorney. I mean, I defended people that were tried with, manslaughter, murder, and
wow.
won those jury trials. So I had a lot of experience. I worked largely in all 4 counties for a long time. I was the public defender, if you will. We didn't have that system back then, but there was a pool of money that they used when the attorneys were appointed, and I got all of them in Pendleton County, and most of the attorneys in Harrison County really didn't want to do it at that time. So I went to Harrison County, I went to Nicholas, to Robertson. I was on the road in all 4 counties. I did a ton of criminal defense work for years. So as far as the criminal end, I was very comfortable with criminal law because I knew the law. I had to know it to defend people. And I defend, as I said, from traffic offenses up to major felonies in all 4 counties. I mean, and tried, several jury trials, defending people. And, it's just, you understand how to do those things through that. And then when you flip over to the prosecution side, which is what I like best, I'd say I enjoy putting people in jail more than I like keeping them out of it. Because, sometimes you knew people were guilty and you try to work and get a good plea agreement. It's the duty of the Commonwealth to prove their case.
And that was when you were a defense attorney?
When I was a defense attorney. And, so I had that experience. Now, stepping over into the civil side with the fiscal court, I had been city attorney for Falmouth. So I had some experience in that before I became county attorney. There are some things that are very similar between cities and county, but there are also some big differences as well. So, I used to have to do a little bit more research. I would do reading before I took office to try to get familiar. I went to training. I have taken a ton of continuing legal education. In fact, I get enough every year of continuing legal education. I get the Continuing Education Legal Award by the Kentucky Bar Association, staying abreast of law in general, but then a lot of it through prosecutor conferences and county attorney association meetings that keep us abreast both on the criminal and the civil side.
Are you required to, because I know like the police do, teachers do, we're required so many hours.
Yes,
do you have to?
Yeah, we're required a certain number of hours in general, plus 2 hours every year of ethics.
Okay.
Plus our, including our regular education, so you have to have that.
And no lawyer ethics jokes out there. We don't need those because they're thinking that.
Well, I know a bunch of them too. So, but yeah, there are good lawyers. There's ethical and there's unethical. It's like any
profession.
Life.
Yes.
But yeah, we're required. Every attorney is required to have a certain amount of hours continuing education. If you exceed those by a certain number of hours, you qualify for what's called a Continuing Education Legal Education Award, which I hold, my son Bryant holds. Denise has held it, but she's basically in retirement now, so she gets her requirements to keep her license active and so forth. But yeah, so I do a lot of that, and then just all the years of experience. It's like it's not too often that they'll come up with something I'm going to say. Now, every now and then, because we got some creative minds on that board, but that's one like, I never heard that one before. A lot of times it's pretty much, sorry.
I think I sent one to you from the Florence or the hurricane.
Yes, you did.
That was a unique one. There.
Yes, it was, and it's so there are some things that, like I say, that come up and it's like, let me think common sense. I know what common sense wants me to say, but. And I'm never afraid to say, hey guys, my gut is this, but, let me, and that's one of the things I really do appreciate. Oftentimes I will get that question before it comes up in the meeting, so I have time to look at it. But there are times there at the meeting, someone comes up with something and or something gets added to the agenda that I wasn't aware of. but just experience, I think, is the biggest teacher. Using, those things. Most of your criminal statutes, I can read the elements off without having to look the book up.
Yeah.
Most of my, I don't even have to look up the statute number. It's just I've dealt with them so long. So I think experience is the big thing. That I have a ton of experience as a defense attorney, as a district judge, and then as a county attorney. That I just think it's invaluable experiences. I think anything you do, whatever your trade is, the more experience you have, the less you are taken by surprise with something.
Mm-hmm.
I am very seldom taken by surprise in a criminal trial, because usually I've seen that defense, and usually I because I did defense work or I've seen it so much, I know it's coming.
Yeah.
And I'm ready for it.
Mm-hmm.
So those things all play a role. And when I try jury trials, it's I know what they're going to do, and a lot of times I'll get up my opening statements and things, and I'll just go right to their defense right away.
Mm-hmm.
And when I'm voir diring the jury and questioning that jury, I'll ask them the question. The best compliment I ever got at a jury trial was one of the defense attorneys got up and said, "Well, Mr. Dean asked all the questions I was going to ask you, so I only got one or two more to ask." I got a winner, and I did.
Well, that's a great segue, because I wanted to give you an opportunity. Miss Sanning ran an ad a couple weeks back in the Falmouth Outlook that mentioned the last time there was a jury trial for county attorney, not Commonwealth,
Right.
felonies, those kind of things, was July 2010, I believe it was. I don't know the exact date, but I think it was July 2010. Wanted to touch base about, I don't know enough about the law and how things work to know if that's a bad thing, a good thing, a common thing. I don't know.
Well, I think my response is, number one, I know when I saw that, I went back and looked through some of my notes, and I know I had a trial outline from a jury trial somewhere in at least 2012 that I know went to jury trial. Now, a couple of things. One thing is, our Chief Justice Minton, Kentucky Supreme Court, a couple years ago at the Kentucky Bar Association meeting, was crying about the fact that lawyers are not trying cases to juries anymore. He said, I just hate that young lawyers aren't trying cases to juries anymore. And he said, we're losing that. So you see that, but there have been some things that have happened. When I told you I was Don Wells' unfunded assistant, well, for a couple of years before I became county attorney again, I was appointed as a funded assistant by the state, a part-time assistant prosecutor, where I had prosecutorial duties, not just child support. And I covered some court cases for Don. I started trying all the jury trials for him. So starting in about 2005, every jury trial that was held, I was the prosecutor on that case. So from 2005 to about 2012, I tried several jury trials. And they, against top flight attorneys, I mean, just some of your better attorneys from Northern Kentucky that would come down and try their cases.
And what kind of cases would that be?
Most
what
of
kind
them
charges?
were DUI,
Okay.
driving under the influence. In the old days, everybody would try those to a jury because juries were very sympathetic to drunk drivers and oftentimes let them go. Or, the prosecutors just didn't have the desire. So most of them were DUIs. There were a few that were other criminal type charges. Most of them were DUIs. But the real thing is, with all those jury trials that I tried, every one of them resulted in a guilty verdict. I did not lose a jury trial between 2005 and 2012. Every one of them was a guilty verdict. And a good number of them, when they were found guilty, their clients went to jail.
Okay.
And our recommendations on DUI pleas are more harsh than any of the Northern Kentucky counties. Pendleton, Harrison, Nicholas, and Robertson for years have had a policy on a DUI second offense that you serve 15 days in jail. Well, the law says you have to serve 7. Our recommendation, if you plead guilty, is 15 days in jail. Those attorneys are pleading those people guilty and letting them serve the 15 days in jail in this county. They're pleading them guilty because they have seen, I think, that our juries are not going to put up with people coming in trying to win DUI jury trials. So I say every single one of them, the defendant was found guilty, And in general, they got a penalty that was more harsh than what they would have got if they had pled guilty. So I think that, personally, is the reason a lot of them have quit trying them. The Commonwealth cannot ask for a jury trial. I cannot go in a district court case and demand a jury trial. I think the circuit court, the Commonwealth attorney maybe can, but I cannot. So a defendant has the right to say, I want a jury trial or I want a bench trial, which is just a trial in front of the judge. It's up to them. And if they're all requesting bench trials, I can't change that.
So have you had bench trials?
Oh, yeah.
And a bench trial is a judge making it a
You
case.
do everything except it's the judge makes the decision.
So when's the last time you've had a bench trial?
It's probably been a couple months ago. Again, a lot of people plead guilty.
Okay.
I mean, or we reach some sort of plea agreement that reaches that. Sometimes people, I'm offer a diversion with the victim's consent to get somebody, some people say, I just want them to leave me alone. I don't care if they go to jail. And so I said, well, here's a diversion program I've got. If they'll do this, this, and this, how you feel about that? And I said, that's fine. I just want to leave me alone. So we'll do a diversion.
But let me, just to make sure we're clear, if you want to go to trial, bench or jury, you don't have that choice. If the defense attorney says, we want a bench trial, you go to a bench trial no matter what you want or what to do.
No matter what I want.
Okay.
It has to be a bench trial. I cannot ask for a jury trial.
And the judge can't rule and say a jury trial
No.
if the defense. So it's the defense choice
It's
whether it's going to be a jury trial or not.
So you have the right to a trial by jury.
Uh-huh.
You have that right as a defendant, but you do not have to exercise that right. So, there are some cases that get set for a jury trial, but by the time it rolls around, we have to do what's called discovery. I give them all my evidence. A few years back, Kentucky passed a law that said it's illegal to drive under the influence if your blood test is .08 or higher within 2 hours of the cessation of operation. So that meant that you are guilty. I don't have to show that you were under the influence. I don't have to show you had bad driving. I just have to show that you were operating or under physical control of a motor vehicle, and while doing so, within 2 hours of the last time you drove, you had a blood alcohol content of .08 or greater.
Okay.
That won a lot of jury trials.
So it's cut and dry.
To an extent.
Yeah.
I mean, there are still variables. I mean, the defense attorneys now look, well, did the test come after 2 hours?
Okay.
Sometimes it does.
Okay.
And if it does, then I lose that. I lose that ability to try. I can still try the case, but now I have to prove other elements. I have to show that you were under the influence, that there was bad driving. So, if it's beyond that 2 hour window, it's still a triable case. It's a different kind of case now to try. And, I've had some where there were like 4 hours beyond that 2 hour window. And that's just a bad case.
Yeah.
I mean, that's just a bad case. So,
as a prosecuting attorney, are you bound? Because I know you all have ethical rules that is well known as far as what you're allowed to do and zealously defend and all those kind of things. But as a prosecutor, do you have guidelines that you must abide by before you do charges, before you decide to try a case? That I mean, can you legally try a case that you really don't think you can win?
If I know I cannot win that case, ethically, I'm bound to dismiss it or not bring the charge. I mean, that's an ethical violation. If you bring a bogus charge, that's basically what you're doing. Mm-hmm. If you know you cannot win, then ethically, you should not try that case. Even though, it might be a case you think I can hoodwink the jury into doing. The judge will see right through it, but I might be able to hoodwink a jury into this. That's unethical. And so, I am held to a different standard. I have the duty to protect not only the taxpayers, the victims, but I also have to make sure that the defendant's rights are protected. Under discovery rules, I have to give them everything I have. Mm-hmm. If I withhold something, I can be in deep trouble. And if it's found out later that I withheld something, that case is going to be appealed, it's going to be reversed, and, it's just this situation that I have a duty. My duty is justice. It's playing by the rules. I don't have that duty to zealously prosecute like they have zealously defend. Now, if I think it's a winner or, it has a reasonable chance of winning, yes, and I'm gonna zealously prosecute. I'm gonna do everything to my ability to bring that to a conclusion with a guilty plea or a guilty verdict, or somewhere in between by agreement of all the parties. Plea bargaining has a bad word to it, but if we tried every case, we'd never get through the docket. Plea agreements are pretty consistent between the 4 counties. The judges have said this is what I'll take and what I won't in a lot of cases. And if you deviate from that, you have to say why, and you have to convince the judge that this is why I'm doing something different.
I know the sheriff candidates have said that they know what will win a case in front of judges. And so they build their cases to a minimum of that level, that they're not going to bring a case forward until they've got to that level. Is that kind of what you're saying? You kind of know.
You really should. You should not charge somebody in hopes that you can develop a case.
Okay.
How would you feel if someone charged you with a crime because, well, I think you did it, Keith.
Yeah.
And I'm going to charge you because now if I get you arrested, I can take you down. Maybe you'll confess to it. Or maybe before you get to trial, I'll develop enough evidence to convict you. That's not fair. Okay. That's not right. You should have your case. That doesn't mean there's not still more investigation that maybe needs to be done. And that's not to say that when you start looking at everything that you find things in the case that are weaknesses as a prosecutor, and things that maybe, I wish they'd talked to me before they did that because that's maybe not quite right. Generally they do a good job, but every now and then, like I say, you see that case, the DUI, where the blood test is 4 hours after the guy was picked up.
Yeah.
And, those are the cases of prosecutor you got to look at and say, I know I've got a big problem here. I've got a really big problem. Now, then I have to decide, okay, can I win it, even with the problem? If I can, then I'm going to prosecute it, but I also know that it's a much weaker case. So those are the cases sometimes, as I say, we normally give 15 days in jail on the use. I may say, I have got some major problems. Now, is this a triable case? Yes. Is it a winnable case? Maybe. Do I need to maybe say, okay, look, we normally recommend 15 days. Look, I'll take 7 this time because I recognize, and the defense attorneys know it, because the good ones, they know how I operate. They'll come and tell me, say, here's your big problem. Because they trust me that I'll look at it and do an honest assessment. Some of them will just come and say, here's where I think your issue is, and here's your problem. And usually I've already seen it too. And then when we go to the judge, we have to say, Judge, here's the big problem. And this is why I'm deviating from what we normally recommend.
Gotcha.
because and the judge, Judge Custer's been practicing it just a year less than I have. He was at UK and graduated a year behind me. He graduated to these. And it's like, he's been around too, and is a former prosecutor. He knows. And so, say, Judge, here's the problem. And, occasionally you have to amend it to a reckless driving because you've got such a weak DUI case. But by law, I have to put reasons on the record why I'm amending a DUI. You can't just go in. When I first started practice, first time you got a DUI in Pendleton County was automatic amended to a reckless driving.
Who made that rule?
Oh, it was just the rule.
But the rule made by state, by the local,
it was just
by the judge?
Because, the judge, the attorneys, it was pretty much, you were a local guy, you got picked up for DUI.
Wow.
Yeah, you get a reckless. It's the first time you ever had one.
That's what they call the good old boy network.
Well, and it was just, it was the days before, Mad Mothers and the days before it got the attention that it's gotten, which, it shouldn't be that way. Mm-hmm. But that's the way it was.
Yeah.
Now, by law, if it's filed, I have to prosecute it. I, by law, cannot make amendments unless I can justify on the record with the judge why I am amending this case. And I have to show why. And there are certain things I cannot amend down. But even so, there are still cases that have problems sometimes. You have to do something. But for the most part, if it's a clean case, in a DUI, if they want a jury trial, I'm ready to go. Mm-hmm. Let's go. Because I haven't lost one in years.
Yeah.
and I'm ready to tee it up and let's see what that jury says. And when your guy gets sent to jail at the end of the day, it's on you because you didn't tell him.
So those old football juices playing in Bellevue, they start, the adrenaline starts pumping again.
I love to try a jury trial. I mean, it's sort of the work to get ready for it is like, and you sort of get all that nervous energy. But man, when you hit the floor and you're ready to go, I've had attorneys and I've had judges say, I've never seen that side of you before. Because when we're at a jury trial, we're playing for all the marbles because they're playing to walk away with nothing.
Yeah.
I'm playing to get as much as I can. And I always ask that jury, I said, is there anybody on this panel that if the evidence so requires that cannot give this defendant, I never call him by name, this defendant the maximum penalty that the law will allow? And I want to see every head go, yes, I can do that, that I will do that. Because when I come back on closing, I'm going to hold them to that promise that they made me.
Okay.
So it's a different, when we're going toe to toe with a jury, those juices flow and I don't like to lose, and I haven't lost one in a long time.
Gotcha.
And it's, so, whether it's me, whether it's the change of law, whether it's the juries, I've had a lot of defense attorneys tell me why they think it is that our juries do that. I don't always agree with it. I think people are just tired of drunk drivers being out and being a menace to society, and they have good heads on their shoulders. And I prosecuted really good years ago, a really fine, outstanding citizen, helped me and pushed my son out of a snowbank even. A few months before.
Yeah.
Tried him for DUI second. He got a bunch of jail time. He got 4 months of community service and a ton of fines. And Ray Baguki was his attorney, and midway through the deliberation of the jury, he came and asked, will you accept, if he wants to plead now, take the offer you made? He was like, not a chance. You want to go to jury trial? We're here. Whatever. If the jury says he's let go, he can go home. But if not, if they say he's going to jail, they'll put the cuffs on him. He'll leave this courtroom today on his way to jail. And I think that, has stopped people asking for jury trials. I mean, that's, my opponent says I haven't. I did some checking, after all this. I found through the state system that in 20 years she's listed as the defense attorney on 75 cases statewide. 75. 19 of those were in Pendleton County for criminal or traffic offenses. That's statewide in 20 years. None of them were tried to a jury.
Interesting.
Not a single one. I checked, I went through all 75 cases to see what it was, and a lot of them were guilty, no trial. Guilty, no trial. Or, there were some that bench trial. Got them right here with me. So, you want to talk jury trials? Let's talk jury trials. I mean, I have always said I'm going to run for me. But when you're questioning my ability to try a case in front of a jury, I'll go toe to toe with anyone on a jury trial. I did it as a defense attorney. I've done it as a prosecutor. And I have been very successful with juries. And as I say, I have tried homicide cases to a jury. Tried Eddie Hofstetter to a jury trial, a shooting here in the county years ago. First time we got a hung jury, got ready to retry it. Commonwealth attorney offered me, Jack Keith offered me a plea to 3 years in prison for killing a man. I said, I talked to my client, we're not going to take it. We're going to a jury trial. Not guilty. I have experience with juries. I'm not afraid to try a case to a jury. Do it any day anybody wants to. Now, like I say, sometimes they're set and they're resolved. But I've tried a bunch of jury trials in my career. So don't say I can't try a jury trial or that I'm afraid to. I'm already getting my blood up. I say those old days of football come out. I'm not afraid to try to a jury.
Okay.
It's not my call all the time.
I totally understand that.
So that's my response.
Well, hey, we appreciate you coming out. 4-year term, right?
4 years.
All right, so we've ended all these with the same question. Or re-elected January 1st, it would be 2023, would be the end of that term.
Correct.
As a voter, look back at the 4 years, what would you want that voter to notice about this term, of Jeff Dean being the county attorney?
Well, I would just hope that, I've been doing this for a while, and that people have been pleased with how I've done it. Yes, I'll make a mistake here and there, wish I'd done things different, but that they felt the county got quality legal representation, that they got prosecutions that were consistent with what the public would demand, and that, I was an honest, hard-working county attorney, that I took this job to serve the people of this county, and, I'm asking for that privilege one more time. Folks have said, oh, he's gonna win it and retire, and that's not. I will retire at the end of the term from prosecuting. I will not run again.
Okay.
If I'm fortunate enough to be elected at the end of that term, I'll be 66. I won't run again. I want to enjoy life too. I want to avoid those midnight calls and things like that. Not that, it comes with the territory. I'll never complain about them. I know that's what I'm getting into. And, you ask for something and you get it. I have no complaints. But, my son's a young attorney. Joey Vierek's a young attorney. Those guys are coming up. I don't know if Brian even has any desire. But, those guys coming up, let them have their day too. I'll have done enough. And I'm just asking for one more shot to finish out my career as a county attorney. I've always wanted to serve here in the county. I think I've been dedicated to this community over the years. That I've been involved in a lot of things over the years. As you said, a lot of people know me because I have been involved and will continue to be involved. And I think, it's important when you ask people to vote for you that you're giving back. And I hope that they think that, at the end of the day that they say, he did a good job for us and he cared about the people of this community and he worked hard for us.
Okay. Well, hey, thank you for coming in.
Thank you. I appreciate it, Keith.
Enjoy talking. And obviously I enjoy this. I love politics. I love history. Somebody made the comment on Facebook last night that I was discussing. They said, well, I enjoy having these respectful discussions, but maybe that makes me weird. And I replied, well, if you're weird for it, I'm driving the bus because I enjoyed the weirdness to talking. And hopefully you're all enjoying learning a little bit more. That comes from my education background, as well as you all getting informed when you go to cast that vote on November 6th for all these different elections. Again, so appreciative that you're all going to FalmouthOutlook.com. Again, support local businesses. Don't go to YouTube and watch these. Go to FalmouthOutlook.com. That helps us out, helps your local newspaper out, and hopefully you're getting informed on all this. Thank you all for coming in, and check out all the videos on all the candidates that we've been able to do.
Thank you, Keith.
No problem.